My presentation opens with a quote from the greatest Filipino constitutionalist that ever lived, Claro M. Recto. He said, "I am not an idolater of the constitutions. I do not believe that once proclaimed they should forever be carved on tablets of imperishable stone beyond the reach of impious hands. On the contrary, people should be made to live with their constitution. But the caprice of the powerful should not be confused with the anxieties, the longings, the wants, and the will of the people." You know, of course, that Claro M. Recto was president of the first 1934 Constitutional Convention. Let me just go through minor general principles on amendment and revision. First, revision versus amendment. Revision broadly implies a change that alters a basic principle in the Constitution, such as the separation of powers of the system of checks and balances. In Lambino versus Commission on Elections, the Supreme Court, speaking through Justice Antonio Carpio, said there is also revision when there is a change in the substance entirety of the Constitution. Naturally, revision entails changes in various provisions of the Constitution, while amendment refers to a change that adds, reduces, deletes without altering the basic principle involved. It basically affects only a single or identified piecemeal provisions. The related principles that were laid down by the Supreme Court in Lambino are, first, that the Lambino attempt at amending the Constitution did not constitute simply an amendment but a revision, because it proposed the replacement of the presidential with a parliamentary government and the bicameral with a unicameral legislature. The second important principle laid down in Lambino is that a people's initiative can only be made to propose an amendment, not a revision of the Constitution. And finally, Justice Tony Carpio laid down two basic elements to be complied with in a people's amendment on a petition to amend the Constitution, namely that the people must themselves author and sign the petition. They cannot leave this up to an agent. And second, the proposal must itself be embodied in the petition. Then the other principle has to do with constituent as against legislative power. Legislative power is, of course, the power to propose, amend, and repeal laws. This is a power vested in Congress under the 1987 Constitution, except that there is a reservation made with respect to the power of the people through initiative and referendum to propose legislation. The constituent power, on the other hand, is the power to propose amendments to the Constitution, the power to amend or to propose amendments to the Constitution. In Gonzales versus Commission on Elections, the Supreme Court said that this power is lodged in Congress, and that Congress, under the 87 Constitution, is in fact vested with both legislative and constituent powers. Earlier, in Gonzales, what the Supreme Court told us was that the constituent power is the greater power between the two, because it does involve changes in the fundamental law. There is, however, a statement made by the Supreme Court in Sanidad versus Commission on Elections, which does not completely agree with this. In Sanidad, you will remember that the issue was whether or not President Marcos could propose amendments to the Constitution, because the 1973 Constitution only spoke of the interim National Assembly and or the regular National Assembly as the ones vested with constituent authority to propose amendments to the Constitution. But somehow, because there was no interim National Assembly, there was no regular National Assembly at that time, and President Marcos was vested with legislative powers by virtue of that very Constitution. The Supreme Court said the constituent power is merely an adjunct of the gross legislative power. That is how the Supreme Court justified the exercise by President Marcos of the power to propose amendments to the Constitution. Anyway, we do not have an executive who is vested with legislative powers today. Neither are we proposing such a situation in this proposed Constitution. Related principles. Congress may propose amendments to the Constitution because the Constitution already grants the power to Congress. And so Congress is both a legislative body and a constituent assembly. Imbong versus Ferrer is important for purposes of applying the principle that when Congress has already exercised its constituent power, as in this case, Congress had adopted resolutions, of both houses, numbers 1, 2, 3, and then resolution number 4. The Supreme Court said, Congress may then, by simply exercising legislative powers, pass a law providing for the details for the calling of a constitutional convention. In the 1935 Constitution, Congress could directly propose amendments to the Constitution by a vote of 3/4 of all of its members. Or, by a vote of 3/4 also, it could call a constitutional convention to propose amendments. And so, what happened here was, after Congress had passed the resolutions calling for a constitutional convention, Congress then, sitting as a legislative body, passed Republic Act 6735, which provided for the details in the election, in the choosing, in the selection of delegates to the Constitutional Convention. So, a challenge was made precisely by Imbong, because that law was not passed by 3/4 vote of Congress. He said that it had to do with the calling of a constitutional convention, then it was unconstitutional. The Supreme Court said no, because Congress had already voted 3/4 on the resolutions calling for a constitutional convention. It could then, by simply exercising legislative powers, pass a law providing for the details, for the implementation of the 2 resolutions calling for a constitutional convention. The only other principle I want you to remember is that the matter of proposing amendments to the Constitution has always been considered a justiciable question. Why? Because eventually the issue boils down to whether or not the steps